Imagine spending thousands of dollars building a backyard playground for your children. A place to climb, a place to swing, a place to make memories. Your daughters pick their favorite color, purple. You build it, the kids love it. The neighbors don't care. Then, one day, a letter arrives, not from the city, not from the police, not from a court, but from your HOA. And according to that letter, if you don't remove the purple playground, you could end up in jail. Sounds ridiculous, right? But that's exactly what happened to one Missouri family. And when they refused to back down, the fight ended up in court. Here's what happened. In Lee's Summit, Missouri, Jack and Marla Stout wanted to build something special for their daughters. The project wasn't unusual: a backyard playground, a playhouse, a swing set, the type of thing thousands of families install every year. Their daughters were just 5 and 8 years old at the time. Like most children, they had opinions, strong opinions. And when it came to choose a color, they wanted pink. Marla wasn't actually thrilled about pink, so a compromise was reached, and they settled on the color purple. The playground was stained a soft purple color and installed in the family's backyard. At first, nothing happened. The structure sat there for more than a year. The children played on it, neighbors walked by. Life went on. Then the HOA noticed. The Stouts received a notice from the Raintree Lake Properties Owners Association. According to the HOA, the playground color had not been approved. The association claimed that the purple playground was not within harmony with the neighborhood. Now, here's where things get interesting. The HOA rules didn't actually list approved colors. They didn't say purple was banned. They didn't say purple was prohibited. Instead, the rules said playground equipment had to be subdued and within harmony with the colors of the community. Sounded straightforward until you ask a simple question. What does harmony mean? Apparently, the HOA thought purple wasn't harmonious. The Stouts disagreed, and disagreed strongly. The HOA initially imposed fines. The Stouts appealed and won. Most people would think that would end the matter. Well, it didn't. The HOA continued to pursue enforcement. Then came letters. According to Marla Stout, the family received correspondence stating that if the playground wasn't removed, additional legal consequences could follow. The letters referenced fines and court enforcement actions. News coverage at the time focused on possibility that failure to comply with a court order could ultimately result in jail sanctions. That's when the story really exploded nationally, because regardless of legal technicalities, the headline was irresistible: a family facing court action over a purple swing set. What happened next may have been the HOA's biggest problem. The neighbors weren't upset. In fact, many supported the Stouts. Residents could actually see the playground from their homes, signed a petition supporting the family and supporting the HOA's effort. Residents could actually see the playground from their homes, signed a petition supporting the family and opposing the HOA's effort to enforce removal. One neighbor publicly criticized the HOA for spending community money on lawyers and court proceedings over a children's play set. Now think about that. The people most affected by the playground didn't care. Yet the legal battle continued. The dispute eventually landed before a Missouri judge. The HOA sought an injunction. In simple terms, they wanted a court order forcing the Stouts to remove the playground. The HOA argued the structure violated architectural standards. The Stouts argued the rules were vague. After all, where exactly was the rule saying purple was forbidden? There wasn't one. And if homeowners can't clearly determine what's allowed and what isn't, how can those rules be fairly enforced? That became the central issue. Well, on August 28, 2015, the judge ruled against the HOA. The court declined to force the removal of the playground. The Stouts won. The purple playground stayed. After months of controversy, after national headlines, after legal threats, the family got to keep the exact structure they built for their children. Marla Stout later said the dispute had embarrassed the community and cost residents money and reputation, and many observers agreed. This story was never really about a swing set. It was about something bigger. How much control should an HOA have? Should vague language be enough to force homeowners to remove property? Should a board be able to spend community money and community resources fighting over a color? Those questions come up repeatedly in HOA disputes across America, and in this case, a judge decided the answer favored the homeowner. The Stouts weren't trying to challenge the entire HOA system. They weren't trying to start a movement. They just wanted their daughters to have a purple background playground. What they got instead was a lawsuit, national headlines, a court battle, and one of the strangest HOA disputes you'll ever hear about. Because somewhere in Missouri, an entire legal fight happened over a color. And after all the letters, all the meetings, and all the courtroom drama, the purple won.